The learning objectives for tonight, they're on your screen there. We want to overview the risks and responsibilities in the detection and diagnosis of neurological conditions, to consider differential diagnoses of neurological conditions in their clinical presentations, understand the roles of different regulators and health complaint entities, and to consider common pitfalls in optometry practice and appropriate risk management. And our esteemed panel of three will be taking you through this journey over the next 90 minutes. Our first presenter tonight is Steve Leslie. Steve is in private practice in Western Australia, as I mentioned. He concentrates on the care of vision and ocular problems related to health issues or subsequent to acquired brain injuries following stroke, head trauma and neurological disease, such as MS and Parkinson's conditions. Steve has served as National President of the Optometry Australia, formerly OAA, and also National Counsellor for 15 years. He's currently the National President of ACBO, the Australasian College of Behavioural Optometrists. He's regularly called on to provide medico-legal reports for police and lawyers regarding clients who have suffered head injuries due to motor vehicle accidents, falls and assaults, as well as expert opinions in medico-legal issues involving optometrists. As you can see, ladies and gentlemen, his expertise is well ahead of us, and we're really looking forward to hearing from Steve all about protection while practicing, and I'll pass you on to Steve now.
Thanks very much. I guess my experience in this area comes from a combination of areas. One is, of course, my own practice over many years. Second is the patients who are sent to us or who have motor vehicle claims, and therefore I'm providing a report for a lawyer. And the third, of course, is for complaints against optometrists in various areas where I might provide an assessment of their records and their practice and how things perhaps haven't gone the way they should be. This is a slide from a paper published in the UK looking at the claims against optometrists against ophthalmologists, I should say, in the National Health System in the UK. And the most common problems were failure to detect glaucoma, failure to detect retinal detachments, which is not uncommon, obviously, in other countries, and certainly a failure to detect papilledema. And they made the comment that in every case, the patients were young adults or children with migraine symptoms. Now, we'll come to migraine in a little while. And the other issue that's important is that the specialties with the highest mean payment claim, the ones that cost the most to the optometrists, their association, their insurers and the lawyers, were neuro-ophthalmology and paediatric ophthalmology. So I'm going to combine paediatric and neuro-ophthalmology in my presentation. Just a word of warning, we don't have a legal obligation to diagnose brain tumours. That's not our role. But we do have a responsibility to detect signs and symptoms, visual ocular problems of intracranial masses such as tumours, neurological pathology, and obviously papilledema is one of the most common, although there are other things like sudden onset diplopia, sudden onset nystagmus, sixth nerve palsies, etc. The main issue is that you need to have systems in your practice which reduce your risks of committing errors. Doesn't mean you have to be rigid in your structure, but you have to have ways of thinking, how do I work through a process with a patient when the things come up that are a bit different, rather than saying, what am I going to do now? I don't know what to do. Maybe this is this. So there are systems. And when I assess these claims, the thing that I think about often is that it could happen to me. I could have made the same mistakes. If my systems are not systematic, if I don't keep good records, which I'll go on and on about over and over again, if I don't maintain a healthy level of concern where things are just a bit different, and if I don't delay to people when it's suspicious, do perimetry, do ACT when it's indicated, and the other thing, of course, is record the results, whether they're positive or negative. Now, this is a case that came to me many years ago by lawyers because she was suing a hospital. It's a 22-year-old female, hairdresser, sudden onset headache. GP referred her to a teaching hospital in Perth with, just rule out a brain aneurysm was the recommendation. After a few hours, the headache got better. They diagnosed with migraine, sent her home. A week later, the brain aneurysm ruptured with catastrophic consequences, and the hospital settled eventually for millions of dollars. The aneurysm was so bad, or the leak was so bad, that it went down the optic nerve into the eyeballs, a condition called Terson syndrome. This is a picture somewhat like hers. major issues, retinal detachment surgery. She has constant double vision. She has impaired eye movements, major cognitive issues as well, and she's under lifelong care. So the lesson you learn from that is many people, as you know, in practice, call a bad headache a migraine. You know, I ask questions whenever someone says that, and the questions asked is, when was the first time? Is it getting better or worse? Is the severity or frequency changing? Is there a family history? Because there typically or often is. Do you get aura, nausea, photophobia? And particularly I ask, are there any neurological signs? Does your speech get slurred? Do you get tingling of your tongue or lips or face or hands? And particularly do the visual symptoms, because aura typically happens before the headache. Aura after a headache is more suspicious. And the other thing, of course, is any episode after 40 is very suspicious. So I tried to delineate the details. Obviously, anything that is increasing in severity, or frequency, where there are other neurological signs and symptoms or other issues, and anyone who's had a first episode, migraine is a diagnosis by exclusion, and you'll hear that phrase a lot of times tonight. You have to exclude other things to a reasonable level before you say, oh, it's migraine. So it's a reduction of amblyopia is another diagnosis by exclusion. You have reduced acuity. Now, you might say, oh, well, they've got reduced acuity, they must have amblyopia. I want to find out why they have amblyopia. There has to be an amblyogenic agent, something that caused the amblyopia, not just the vision is worse in one eye. There's a constant strabismus. There's significant anesiometropia, or maybe you had congenital cataract. Usually there's going to be a reason that you can pick up straight away from the history, let alone your exam. And you have to rule out pathology. So it's a diagnosis by exclusion, especially in children, and you must assume it's a serious underlying condition until you've excluded reasonably possibilities. You don't have to go to become a neuro-ophthalmologist to do it. This is a case referred to me by for amblyopia vision therapy, treated for 6 months by another optometrist, VA 630, no strabismus, no significant anesiometropia. But why? Do they have amblyopia? Well, when you take a fundus photo, this is what you found. They had a toxocara infection at the macula, which was causing, this is not their photo, but it's similar. And yet this wasn't picked up and recorded by the initial optometrist. These are usually there are papers on this ad infinitum about the degrees of an isoametropia or anesiometropia that can cause amblyopia. They're not hard and fast, but they're reasonable rules of thumb. And so when you're above these levels of astigmatism, hyperopia, and myopia, you can reasonably assume that they could be amblyogenic or amblyopia-genic in the literature at times. So you then rule out neurological company, and the way that we do it in our practice, we have a form that we pull out when there's a need for this, and we just ask questions and tick boxes, yes or no. We then scan that into our records as a record of what questions we've asked and what the patient has said in response. So you can prove that you've provided good care in a systematic way and you've got a record of it. Now, the other thing that's important, again, I'll keep saying this, is that you don't record things just when they're wrong or I've got a headache. You can say, tick a box that says patient denies headaches, something like that. You must record normal answers rather than abnormal answers only. So we ask these questions. Do you get transient obscurations, numbness, fits, speech problems, pain, headaches? And this is the one that I ask all the time of parents of children. They're saying, my child gets a headache a lot, and we'll come to this later. I asked, when does the headache happen? When, in the morning, after school? Do they get them during the night? Do they wake up in the morning? Do they wake during the night with headaches? Headaches during the night, waking the child, often diagnosed as abdominal migraine by paediatricians, are a warning sign, and you must check out other things. Is basically this child healthy and happy? Are they lethargic? Are they really crying, unhappy all the time? It's a warning sign. And the biggest issue is if you don't ask these questions, the patient won't volunteer this a lot of the time. They don't connect these issues with the problems that you're looking at or that might be there. So this is a child detected at school with poor visual acuity by saw two optometrists or an ophthalmologist. Diagnosis was mild bullseye maculopathy pigment, nothing special. VAs, by the time they were seen, was 660 in each eye. The diagnosis by the ophthalmologist was factitious vision loss. I saw the report. And basically they were saying there was malingering going on. Malingering is a diagnosis by exclusion of pathology. And this is the photo. You can look at that and think, well, it's a bit unusual. But it is particular to its specific condition. This is a photo of another patient, a bit older, who we had been diagnosed with malingering that I saw. You can see there's a slightly pale temporal aspect to the optic nerve, and there are all of these fishtail type lesions around the macula and in the mid-periphery, and she had Stargardt's disease. So Stargardt's disease is often difficult to pick up in the early stages. Functional visual loss is often diagnosed. And there's things that can often be said are things like malingering, Streff syndrome. In the ophthalmological literature, there's a phrase juvenile non-malingering binocular amblyopia. But they're all basically ways of saying this is malingering or hysterical amblyopia. And amblyopia or malingering is a diagnosis by exclusion. Another case, child 624 in one eye, 69 in the other. Look at the refraction. There's not really significant anisometropia. There's no strabismus. Why is this child having a reduced acuity? And in the record that I reviewed, there was a question mark, intermittent esotropia. Now, esotropia, you've got to follow it up, start measuring it, asking questions about when did it first start, is it constant, is it intermittent, looking at the degree. There was a question mark about an abduction deficit. The optometrist thought, well, maybe there's something like that, but did nothing else to follow it up. And this is an abduction deficit. The patient is looking to the left, as the arrow says, on their left. The right eye is going, the left eye just doesn't go because the sixth nerve is not working properly to pull the eye out. You'll often see the right eye go crazy because the left eye is working like hell. The right eye works like hell and goes overboard, go looking to the left. So you get overaction of the good eye, which looks to be the problem, but it's in fact the other eye that's affected. Pupil reactions were said to be normal. The problem was in this optometrist record, there was no record of pupil reactions. They just said, I measured them, they were normal, I didn't write it down. I'd only write it down when there's nothing abnormal. And the optometrist said in defence, I did a dilated pupil exam, but there was nothing wrong, so I wrote nothing down. If in court, if you don't have a record, it didn't happen as far as the court's concerned. So you must write down normal as well as abnormal test results. This is what happened. 15 months later, things had changed. 8 months later, another office exam. They went to another optometrist. If this happens, if someone sees you, things are just a bit unusual, try to get in contact with the previous optometrist, get the patient's permission or parent, and find details about what happened. In this case, the vision was now 660, 624. It had been treated as functional problems for a while, malingering. There was bilateral optic atrophy and there was a craniopharyngioma. This is the actual scan with a very poor outcome for the child. So, lessons. The mother had told the GP a number of times the child was waking with headaches, vomiting. Didn't tell the optometrist because the optometrist did not ask. It's important to rule out neurological company, which is the phrase in the literature and in practice. When acuities get worse despite treatment, start to think about again. Don't just go with the same diagnosis, because if the diagnosis doesn't fit what's going on, start from scratch and just think, maybe I didn't go down the right path in the first place, or someone else didn't go down that path. This is another case, preschooler with blurred vision, persistent headaches, clumsiness. That doesn't sound good straight away. There's reduced acuity in one eye. +2, that shouldn't cause that so badly. Was treated by an optometrist for 17 weeks, didn't get better. The ophthalmoscopy was recorded as normal until finally, this is, by the way, the photo that the first optometrist took. Now, you might look at that and think, well, it looks, reasonably normal, bit of a funny pigmented macula. But look at the nasal disc and the superior and inferior disc. The first stage of papilledema, and we'll come to this, is swelling of the nasal superior and inferior. There's a C-shaped halo of swelling, which you must look for as an early sign, stage 1 papilledema. And the temporal disc remains normal in the early stages, but eventually becomes atrophic over time. So if you miss or don't record evidence of possible pathology in a retinal image, OCT, perimetry, whatever, and I'll come to this about children, try visual fields, we'll talk about that, they'll be used against you in a case, by APRA or in a legal case. I've seen a number of cases where on the old registration board in Western Australia, we looked at the fundus photos of a case where an optometrist was complained against, and it was obvious there was a retinal detachment or papilledema. So it hadn't been picked up, not obvious, but it was there. You really couldn't miss it if you look carefully. The other thing, of course, which will be talked about later, is that make sure you're looking at that patient's record and not someone else's. Because if you've got ancillary staff taking the photos, you need to be sure you've clicked on the right one. So in this case, we've found that the person is looking bad. The optometrist finally did a dilated exam and found bilateral papilledema. Sorry, it was unilateral, but worse in one eye. They had optic atrophy, which means it's been there a long time. And that was due to hydrocephalus, due to an intracranial mass. Very serious outcome. And unfortunately, again, the outcome for a child of that age is not good for long term. Now, it's very easy to assume that a disc that looks a bit funny is pseudopapilledema. Again, you assume that it's papilledema until proven otherwise, and there are ways you work through that process. So papilledema is a bit different in appearance and clinical results, and I'm just going to talk about this because it's a way of thinking through the process, taking reasonable steps to assess the situation and deciding, okay, it is pseudopapilledema. I don't need to send them off to a teaching hospital now in an ambulance. I just need to monitor this, record my findings, and follow it in time. So Frisane is probably the most widely used scale of papilledema, and you get the C-shaped nasal, superior, inferior swelling, and temporal is unaffected in the first step. You can see obviously in these that there's also some tortuosity. Now, but tortuosity can happen normally anyway, so you can't just bank on that. That's the first level. Second level is the whole disc starts to become swollen, and you get other changes. But again, now you can get this appearance with a pseudopapilledema, and we'll come to that. And the one thing that you need to look at with that is what's missing. What do you expect from papilledema a lot of the time that isn't there? And the answer is hemorrhages. The research, and Frisane, who's done this work, says subretinal, periretinal, intraretinal hemorrhages are non-essential findings for papilledema. You don't have to see hemorrhages to say it's papilledema. An absence of hemorrhages doesn't rule it out. So look at the disc, particularly the nasal aspect. Now, we have an OCT, we're lucky enough to have one. We routinely do any child or adult who has an unusual looking disc OCT as a baseline, as well as a way of differential diagnosis. And the difference is that in papilledema, the outside of the retinal nerve fibre layer around the disc is swollen, whereas in pseudopapilledema, it's the disc itself. So you can differentiate that by certainly you do a dilated exam with binocular indirect ophthalmoscopy, but you also do OCT if you can. And the reason is that the intracranial pressure is transmitted up the subarachnoid space on the edge of the nerve, and therefore the edge of the nerve goes up, the neuroretinal rim around the disc, and you get a picture just like this with this volcano sign, where basically the center of the disc is now down where it used to be, but the edge of the disc around it is raised everywhere. You get this, what we call double hump picture on your right, where basically it means that the rim of the disc, or the neuroretinal rim, and if you went to your line scale in the OCT, you're going to see the neuroretinal rim raised, but the nerve fibre layer, sorry, what am I saying? Nerve fibre layer, neuroretinal rim. The disc itself looks flat, but the edge of the disc around it is raised. The retinal nerve fibre is raised rather than neuroretinal rim. What you have on your left is pseudopapilledema. The disc is up, but the periphery is down. So use the OCT if you can. Try to do fields on children, at least you've attempted it. Do confrontation if you have to. It's amazing how many children can do fields at a reasonable age. So, and also if you're going to diagnose pseudopapilledema, there has to be an explanation most of the time. The most common reason is optic nerve hypoplasia, which is usually recognised as a small pale disc surrounded by a double ring effect. You get this double ring, which shows you it's a very small disc, and if you do OCT, it'll pick that it's a very small disc. Optic disc drusen. Now, interestingly, that happens, one study shows about 0.4% of children, which is about 1 in 250. I've seen papers recently which suggest it can be up to 1 in 50 children. So it's not uncommon. It's not obvious when they're young because the disc drusen just come through over time. But again, in an OCT, you'll get a lumpy, bumpy appearance of the disc. You see the buried disc drusen sort of in little lumps and bumps. So OCT is a good baseline as well as differential diagnosis. So when you've got a raised disc and you think, it looks okay, but it's a bit raised, a bit funny, do a history, rule out neurological company. Make sure that you understand the differences I've just talked about, and there are papers around, and I've given lectures on this in the past at some of the state conferences. Record your results. Just write down your thinking. I think this is pseudopapilledema because there's a double ring effect of optic nerve hypoplasia, or the ACT shows lumpy, bumpy appearance. Do a dilated pupil exam, binocular indirect, write the results down. Record the diagnosis in your records, and that's one of the issues that I often see in records I'm reviewing. There is no diagnosis in the record. So I don't know why someone has done what they've done. Obviously, they're supposed to infer it from the findings, but you should write down a diagnosis, which I'll come to. Now, it has to be said that pseudopapilledema sometimes doesn't have an obvious explanation. In any of these cases, you would normally follow them over time to make sure things don't change and compare to your baseline. In terms of taking a history, we use a welcome to the office form. Patients fill it out online, send it back, hopefully beforehand, otherwise bring it in. If they don't do that because they didn't have time, they couldn't print it out, then they do it when they come to the office. The staff give it to them, they fill it out, staff scan it in, it's on my record on the computer when I get there, and they'll show it to me as well in hard copy. You have a record of what the questions asked of that patient and what their answers were. So again, you're protecting your back from things that you should have asked to some degree. The other thing is listen to your patient. One study shows that physicians interrupt a patient after 18 seconds. And when I ask a lot of questions, and I sometimes say to people, I'm going to ask you a lot of questions because a lot of the time you're going to give me clues that you hadn't thought connected, but it's worthwhile just asking these, usually to rule out that there's anything else going on. And one of the lectures I give is, my child has a headache, do they have a brain tumour? So I like to ask questions to sort of say, well, they don't have this, they don't have that, they don't have that. Therefore, it's less and less likely that there's anything sinister going on. The problem is that it's too easy to jump to a conclusion. The patient talks to you for 18 seconds, you sort of, okay, let's do the refraction and the visual acuities. And it's easy to miss things that you should have picked up by asking a few more questions or by looking at your welcome to the office form, because they will give you their presenting symptom. They don't give you other things that they haven't thought of to tell you about at the time. So you need to ask. It doesn't take that long. The other thing is that it's easy in our day and age to think that with our technology that the answers will be in our tests. That we'll do more and more tests. We've got the OCT, we've got wide field imaging, we've got the retinal photo, everything will be there and I'll just have to do the tests and the result will be there. It's very common. First of all, make sure you've got the right images, as I said. It's also important that you look at each image or test result that you get from your staff or you do yourself, record your findings, your interpretation of that. And it's easy to skip taking a good history and listening. A neuro-ophthalmologist I worked with for many years in the desert used to say to me that if you ask enough questions, within 90 seconds the patient will give you the diagnosis in about 80% of the cases. So I ask a lot of questions before they get to see me and when they're there. And it's amazing what they say. For instance, one patient my colleague saw, had, some visual symptoms, 20-something-year-old boy, didn't and we couldn't figure out why, he had these symptoms and why he had a bit of unusual optic nerves and why he had neurological signs, and kept asking questions. And he said, no, nothing's ever happened to me, never had a head injury, never had concussion, whiplash, never had any neurological disease, had a normal birth. And then he said, well, when I was 15, I fell into a wheat silo and died 3 ways onto the hospital from suffocation. Is that important? Well, it probably is. But people don't connect it until you start asking it and they make a connection with your leading questions. The other thing is, again, record results, positive, negative. Record visual acuity, record binocular vision, normal. Record pupil reactions, normal, no RAPD. And the important thing is, and this is something I come up against a lot in records, record structures in a sequential health assessment. Don't just say, ocular health normal. That's not enough. You'll get crucified in a complaint. You can do it by tick boxes, and so I'll show you the Optomate example, or you can do it in words, AC, anterior chamber, D and Q, deep and quiet, lenses clear, macula clear, or normal. General terms are risky. If you say eye health normal, you will be in trouble. If you say NAD, no abnormality detected, it's not enough. And if you say WNL, within normal limits, in court it means we never looked, we wrote something down. So don't say those things, record sequentially. And this is from the Optomate tick box format, both in terms of the result, the posterior assessment. You can tick the boxes, have pre-formatted tick box choices, things that's come down for you to choose from. And then you can also record the categories. In our case, so these are diagnoses, but Optomate calls them categories. I'm sure Sunix has similar systems. But these are things that alert me straight away to the things that this patient has from previously. It's in medical terms the problem-oriented medical reticle keeper system, which is what the AMA does for doctors as their typical general medical practitioner record system, problem-orientated medical records. So you know diagnoses immediately when you see that patient a year or two later, or 5 years or 10 years later. So listen, many patients do not connect issues in their history or their child's history, particularly with their visual issues. You need to ask questions, listen, write down the answers, even if they're normal. You've recorded, you've asked the questions, you therefore have a good defence if anything happens to you. And you might be surprised at the answers you get that hadn't quite been expected. Many people will give you their diagnosis. I mean, I say that flippantly, but it happens so many times because it starts to form a pattern in the questions that you ask, the answers they give you. You start to think about syndromes, at the course of a history of a particular problem like Stargardt disease or retinitis pigmentosa or a rate intracranial pressure, which is worse at night, and that's why children wake up vomiting or wake up with headaches during the night or also during the morning. And if necessary, use a neurological company form. Take the points that I've listed there put them on a form, have it ready for you, pull it out, ask them questions, tick boxes, yes, put yes or no next to them, scan it into their record or have it in your paper record if you do, and you've got a record that you asked these questions that made you what a good optometrist would do, and the legal term is what a patient would expect of a good optometrist, that you would do this care in the best way possible. The other thing is, how are your follow-up systems? Record in your records the recommended review period. Now, you're thinking, I don't have time to do all this stuff. It's going to take forever. I'll be there for 2 hours. It doesn't take long if you have a system. And I'm not a systematic person by nature, but I've learnt to be, so I minimise my chances of these issues happening to me and to my patients somewhere, especially in the work that I do with neurological issues. Impress on them. This is a potentially serious issue in cases of, possible neurological problems, but you feel it's okay to monitor it yourself. And this, by the way, is a comfort zone thing. There are some cases, which you think, I'm not sure what's going on, I'll refer them off. If you're going to refer them to an ophthalmologist, it'll take 3 months to get an appointment. But they're not probably urgent enough to warrant saying you need to see this patient today or go to the hospital. So you've got to find a way to make a reasonable decision, and that becomes a comfort level that changes over time with experience. So my comfort zone is a lot higher than others because I see these patients all the time, and as a result, I've learned what is a reasonable and not so reasonable thing. So one of the things that came up recently is when you see a 6-year-old who suddenly has an esotropia for the first time, what is reasonable to do and what would make an ophthalmologist order imaging? And there are a number of reasons that you might. 6 years after 6, for instance, is suspicious. Before 6, an acute acquired esotropia is not quite as unusual. At the age of 10, it's very unusual. So you refer straight away for urgent assessment and possible imaging because, bluntly, what does an ophthalmologist do that a good optometrist doesn't do? And the only thing is probably they have perhaps more experience with neurological conditions and they can order imaging and other tests. So it's a comfort zone. They don't expect you to do the way things I do, but you can do a good job by using systems that say, I'm going to ask these questions and I'm going to do these tests and I'm going to write down the results and I've got it all there and then I'm going to follow them up. So in terms of follow-up, how do you know that if they don't return? And that unfortunately happens. One of the cases you saw went to see another optometrist, down the track. They were getting worse. Parent just thought, the kid was sick. You need to have a way of making sure. So we have in our system a flag next to we pre-appoint them, and next to the pre-appointment is a note, if patient cancels or changes, notify me, because I need to look at their record and see why did I want to see them so quickly. If they cancel, I will sometimes ring them and find out what's going on. Now that seems crazy, but it doesn't take long and it protects them and you. At all reviews of reduced visual acuity, look at see whether it's changing or getting worse. And again, how do you ensure a patient actually attends for a referred opinion? I'm sure ophthalmologists will send you a letter to say, patient you referred to me didn't turn up in the last 12 months. That is now their legal requirement, essentially, or their association requirement. And we do the same. We track referrals. If a patient doesn't, we don't get a letter back within a period of time, we start looking to find out why. So you're just protecting yourself and the patient in a reasonable way without going overboard. Systems do it. So how to avoid a complaint, how to avoid getting a letter from APRA or a lawyer. Ask questions, record the results. Record positives and negatives, not just the negatives. Determine why someone has reduced visual acuity. Don't assume it's amblyopia. Dilate if you feel something's going on. You need to look at the disc really well, especially binocularly with stereopsis. If indicated, try visual fields. Even if they're young, you try. And you might be surprised what they can do, and at least you've tried. And carefully check any test images, make sure it's the right patient, record the results in your interpretation, and please record the diagnoses. because, again, you cannot expect someone who's reviewing your records to understand why you did something or didn't see them for 6 months when you should have been, next week, when you don't record what the diagnosis is and what your thinking is. So in the typical medical-orientated, problem-orientated record system, you have the SOAP, subjective, objective, assessment, plan. What's your assessment? What's your plan? Try to record it in a simple, efficient way. One way, as I've showed you, with the conditions in Optometry. Sorry. I'm sorry.
Go back the other way.
Yeah, the other way.
Thanks, Steve. That was fantastic. I'm hoping we didn't inflict too many sleepless nights on our viewers after that presentation, because that was pretty eye-opening, pardon the pun, particularly around, I guess, amblyopia and malingering, and sort of optometrists going, how many times have I diagnosed amblyopia or malingering, and what have I done? So, look, a couple of questions before we move on to Jane. There's more than we can probably get through, but I'll ask a couple of main ones that have come up a couple of times. Steve, what would your advice be to locums that have referred a patient to an ophthalmologist but won't be around for follow-up to attend?
Any locum, certainly in the record system, must be a notification to the practice owner that this patient has unusual issues. You might want to look at the record. What I've done is refer them to an ophthalmologist. You need to check up that they get there.
So the onus is on the locum to still follow up, even if you're not at that practice?
You're the practitioner?
Sure.
Yes.
Okay.
Well, the follow-up in terms of notifying the practitioner, so that the practitioner follows up with their system, not just, the locum goes off and doesn't come back again for 6 months.
Yeah, so if a patient wasn't to attend their referred appointment, the locum should be notified of...
well, the practice should be notified, because the communication will come from that practice. Yes.
Steve, another question that was asked was, you spoke a little bit about imaging fields and OCT in children, those sort of things.
Yep.
A couple of questions around that. Is that something you do routinely, and at what age? And what visual field do you recommend for children?
Okay. We do routine retinal photos on every patient as they walk in the door. Okay. Staff does it. They explain to them what's going on. We have already warned them about the cost. We charge for it. But we do routine retinal imaging. The staff do it. They make the child very happy, the parents there. We generally get very good results. It's very rare that we don't get a photo of the child. I've got it. It's then on my screen in Optometry to look at when I'm talking to the parent. Mm-hmm. We then go through the results. The kids love to see their photos. We sometimes give them a printout pretty quickly so they can take it to show and tell at school. And I can teach them through what's going on. Mm-hmm. In terms of visual fields, OCT, any child with a raised optic nerve, we will do routine OCT. Mm-hmm. We try it. We do, obviously, dilated exam if it's considered suspicious. Visual fields, we do central fields because it's quicker. And we do central screening fields if we just need to get a quick result. The problem is that in papilledema, visual fields are not often that dramatically bad.
Sure.
And so you can't be sure that it's due to the fact that it's a child, it's the first time, they didn't give good attention. Mm-hmm. So it's useful, but it's if you can get a decent result from other tests, then visual fields are just another result that could be helpful. Okay.
And just one final one, if we can squeeze it in. You sort of have a throwaway line there that I noted down around make sure you look at the right image for the right patient. Yep. And obviously in this day and age where a lot of auxiliary staff are doing imaging and, there's files and files sitting in front of you, is that something that in your I guess, experience as an expert in court cases and those sort of things, you've come across mistaken identity or images being read incorrectly?
Yeah, it is. It's pretty rare. Mm-hmm. But even in practice, I'm sure I've certainly found that the patient, for instance, has had photos done when they walk in the door, and then I go to that record of that appointment, pull up the screen and start a new record in Optometry, and the photos come through automatically under instruments. And I look at the record and I realise that's not the patient that I've got in my chair.
It's good advice, yeah.
Okay, and so they've obviously, the staff has chosen the wrong patient name and made the appointment under that name. They've turned up even though they didn't get the SMS to remind them. And it just gets through the system. Now, you also need to make sure you're looking at the latest photos as well, but you need to make sure it's the patient in the chair, it's photos you've got on your screen.
Excellent, great advice. Thank you, Steve. And as I said, we've kind of exhausted the time there and gone a little bit over, but here we are. For all our viewers, there's been a couple of questions about the slide deck under the resources tab. On our end, it seems like the slides should be right. I understand that some of you have got the wrong slide deck in the PDF resources tab. In any event, what we'll do is ensure that everybody gets a copy of the slides in the coming days. So hopefully by tomorrow we'll email you with a copy of the slides for Steve, Jane and Luke. So please stay tuned for that. Our next presenter is Jane Duffy. Jane has a qualification in optometry and law and has practiced in both professions. She combines work at the School of Medicine at Deakin University and works in private optometry practice. Jane served on the Optometry Board of Australia for 9 years and chaired its Scheduled Medicines Advisory Committee. Prior to that, she was the Foundation Executive Officer of the Optometry Council of Australia and New Zealand. In 2014, her contributions to the profession of optometry were acknowledged with an Order of Australia medal. Thanks, Jane. We look forward to hearing from you now.
Thanks, Simon. Thanks for the introduction and thank you for the invitation to take part tonight. In the next 15 or 20 minutes, I'm going to cover the role of the regulators of our profession. In most places in Australia, the regulator is the Optometry Board of Australia in partnership with APRA. In New South Wales, the main regulator for optometrists is the Optometry Council of New South Wales. And in Queensland, complaints about optometrists go first to OHO, the Office of the Health Ombudsman. I'll then describe the role of state and territory-based health complaints entities and how their role differs from that of the regulators. And I'll conclude with a quick overview of the role of the courts when things go wrong in healthcare. So Australia's National Registration Accreditation Scheme, and I should say it's a sort of a national scheme given what I've just said about the way complaints are managed. It started on the 1st of July 2010 when legislation came into force called the Health Practitioner Regulation National Law Act, and the shorthand is the National Law. So this law established national registration boards for initially 10 and now 15 health professions, including optometry, and our board is the Optometry Board of Australia. The national law also established APRA, the Australian Health Practitioner Regulation Agency, and you can think of APRA as the public face of the national scheme for both us as health practitioners and for members of the public. So APRA is the organisation that we renew our registration with each year, and it's also the organisation that members of the public can complain to about any of the 15 health practitioner types who are regulated under the national scheme. When a complaint is lodged with APRA, the APRA staff do an initial assessment, and if the complaint concerns a practitioner's poor health or indicates poor clinical performance or conduct, it then gets referred to the relevant national board. People do complain to APRA about optometrists, but not very often. And as I'll explain, when they do complain, the outcome is, in about half the cases, a decision to take no action against the optometrist. Being asked to give this presentation, maybe think about these things. Why are there so few complaints to APRA about optometrists? And when someone does complain, why is it that frequently no action is taken against the optometrist? And as we'll see, the Optometry Board of Australia is not alone in this regard. The other national boards also have a high rate of not taking action against practitioners who are complained about. Here's some data from APRA's most recent annual report. So as at the middle of last year, there were 5,343 optometrists. We make up 0.8% of the total registrant base of nearly 680,000 health practitioners. And you might be interested to know that nurses and midwives make up 62% of the registrant base. There were 33 complaints about optometrists to APRA in that year, down a bit on the previous year where there were 39. And that equates to 1.1% of optometrists having a complaint made against them. Whereas medical practitioners, the rate was 5.1%. But you need to factor in volume here. Most medical practitioners see many more patients each day than optometrists, and so a higher complaint rate is expected. And it's also true to say that many medical practitioner consultations are complex, and that comes with a higher risk of an adverse outcome. I looked at the complaint rate for chiropractors and podiatrists because, like optometry, it's a relatively small professional group. and I thought they probably see a similar number of patients per day. So you can see that the percentage of podiatrists on the receiving end of a complaint is about the same as optometrists. It's higher for chiropractors, and that may be consistent with chiropractors having a higher risk profile. When a patient makes a complaint to AHPRA about any health practitioner, it gets classified by AHPRA. So here's a breakdown of the types of complaints that were made about optometrists in the most recent reporting year. So most, 17, were related to clinical care. And AHPRA has a range of sub-classifications, including missed or incorrect or delayed diagnoses and delayed referral. Unfortunately, the breakdown of the 17 complaints related to clinical care is not publicly available. There were 5 national law breaches, and these are matters where an optometrist, or includes where an optometrist has a condition on their registration, such as having to undertake certain training, and that condition is not complied with. There were 2 boundary violations, and this is AHPRA jargon for sexual misconduct, and AHPRA's sub-classifications for boundary violations include inappropriate sexual comments or sexual relationships. I think the other classifications are fairly self-explanatory. Since July 2014, the first call of complaints that concerns optometrists in Queensland is the Office of the Health Ombudsman, or OHO. And when a complaint comes in, the OHO staff decide whether or not it should be referred to AHPRA. So the 33 complaints on this slide include 8 that concerned optometrists in Queensland and were referred to AHPRA. AHPRA and the national boards have never dealt with complaints that concern health practitioners in New South Wales. They're managed by the New South Wales Health Care Complaints Commission. And complaints that concern the clinical performance or conduct of a practitioner referred to the relevant professional council, and for optometry, our matters are dealt with by the Optometry Council of New South Wales. In 2016-2017, the Optometry Council of New South Wales received 27 complaints about optometrists. So if we add those 27 to those on the slide, Australia-wide, there were 60 complaints about optometrists to our regulators. Sky Capuccio, who I'm sure you're aware is the General Manager of Policy at Optometry Australia, she tells me that in that year there were over 9 million optometry consults billed to Medicare. So 60 complaints to the regulator is really a drop in the ocean. So why are there so few complaints about optometrists to our regulators? And here's some possible reasons. Firstly, optometrists do a good job. So complaints about our clinical performance or conduct are rare. Another possible reason is that optometrists as a profession are quite good at managing things when patients are unhappy. And often it's relatively easy to provide a satisfactory outcome and therefore head off a complaint. It's possible that there is a lack of public awareness of the existence of the regulators and so under-reporting. It's also possible that the complaint process, is a bit onerous, and so people tend not to complain for that reason. Another possibility is that complaints are managed instead by the State and Territory Health Complaints Entity, which I'll discuss shortly. And when things go seriously wrong in optometry, so when a patient loses their sight because of a missed or delayed diagnosis, usually legal advice is sought about suing in negligence, and these are the matters that don't usually come before the registration board. With regard to the sort of action that registration boards, including the Optometry Board of Australia, can take against registrants, here's a list from the most lenient to the most severe. So the board can issue an optometrist with a caution, and that's something that doesn't appear on the public register. An optometrist can be reprimanded, and that does appear on the public register, usually for a specified period of time. The board can accept an undertaking from an optometrist to do or to refrain from doing something. The board can put conditions on registration, for example, to complete training or to work under supervision for a period of time. Suspension or cancellation of registration can, generally speaking, only be applied by a tribunal or imposed by a tribunal, not by a registration board. So that's what an optometrist can do in the event that the board finds that the optometrist is guilty of unprofessional conduct. But let's have a look and see what the board did in that reporting year. So the board resolved 27 complaints about optometrists. 22.2% or 6 resulted in an optometrist accepting an undertaking or having conditions imposed on their registration. 5 resulted in the optometrist receiving a caution or a reprimand. And 15 resulted in no further action. And this relatively high rate of no further action is consistent with the other professions. So 76% of complaints about medical practitioners and 68% of complaints against podiatrists also led to no further action. With regard to complaints in New South Wales, there were 27 matters closed by the regulator there, and 7 had no further action. So that's about a 30% rate. So as an optometrist, I might find this all rather reassuring in the sense that complaints to our regulators are rare, and if a patient does make a complaint against me, chances are that there'll be no action taken, although based on the data that's probably not quite so true in New South Wales. Just as an aside, if you put yourself in the shoes of a member of the public who was motivated to lodge a complaint against a health practitioner, you might think that's not something that someone would do on a whim. And I suspect that there may be a significant number of patients who are less than impressed by a registration board's decision to take no further action unless it is explained as why that is the case. So here's some relevant research. Every complaint that was lodged with AHPRA over a 2-year period in respect of 10 professions, including optometry, was analysed, and the complaints were followed for up to 4.5 years, but 91% of the complaints were resolved within 2 years. Among the findings of interest was that there was a complaint rate was higher against male practitioners and against older practitioners. And consistent with the data in the most recent AHPRA annual report, 68% of the complaints lodged with AHPRA led to no action against the practitioner. The authors found that the odds of action being imposed were significantly higher when the complaint was about a practitioner's health impairment, say a drug or alcohol issue, or about sexual misconduct. And the authors wondered whether this was related to issues of proof. That is, that allegations of unacceptable clinical performance, say poor communication or poor record keeping, may be harder to prove because it involves a judgment about what is and what isn't acceptable. And I think that health practitioners do tend to tread more warily in this area as compared to when it comes to a health impairment or sexual misconduct. Another interesting finding was that complaints to AHPRA made by employers or by other health practitioners were more likely to lead to a sanction being imposed than if the complaint was made by a patient or by the patient's relative. And that probably makes sense because peers are better placed than patients usually to recognise poor performance and conduct. And it's also consistent with peers only reporting the most serious transgressions and so a greater likelihood of action being taken. I'm confident that the high rate of no further action does not mean that most complaints to AHPRA are groundless. I think that the reason there is a high rate of no further action is that the threshold for the board to take action is not met. So all of the registration boards, including the Optometry Board of Australia, need to comply with AHPRA's regulatory principles, including regulatory principle number 6. It means that if a complaint against an optometrist is upheld, but the evidence is that the optometrist shows good insight into their behaviour and provides evidence that they've taken steps to address the issue, this means that the board members who deal with this are likely to form the view that the optometrist won't be a repeat offender. In other words, the optometrist It is not a current risk and won't be a future risk to the public, and so there's no basis for taking action in line with Regulatory Principle 6. I do worry, though, that Regulatory Principle 7 on the slide there gets a bit lost in the national scheme, and that's the notion that the registration boards also have a role in maintaining public confidence in health practitioners, and the high rate of no further action might run the risk of sending the message to those who complain that national boards are looking after the interests of members of the profession as opposed to the public, which is the registration board's role. So there are lots of things that national boards can't do when there's a complaint about the care that's been provided by a health practitioner. The boards can't, for example, order a practitioner to provide a patient with an explanation or an apology. And AHPRA's complaints portal has relatively recently been amended to make this clear to members of the public. It says, if you are raising a concern for the things mentioned on the slide there, don't complain to us, complain to the health complaints organisation in your jurisdiction. And here's a list of all of the health complaints entities in Australia. A key thing to appreciate is that AHPRA works with the relevant health complaints entities when any complaint is received. So an allegation that an optometrist, say, misdiagnosed or mismanaged a recurrent epithelial erosion, that's clearly a matter for the Optometry Board of Australia, whereas a complaint that relates to a spectacle frame breaking with outside the warranty period is the sort of matter that health complaints entities tend to deal with because they can arrange for compensation. With regard to complaints to health complaints entities about optometrists, again, the numbers are quite small. In Victoria, in the last annual report, there were 27 complaints about optometrists, and when I looked at the other annual reports, the numbers were similar and in proportion with the population in those jurisdictions. So again, very small numbers in the context of over 9 million Medicare consultations that optometrists perform each year. A little bit more about the health complaints entities. They all operate slightly differently, but they all have the following features in common, and they're listed there on the slide. These entities really serve a very important function because they are a free and confidential way for people who have a complaint about a health service to get them resolved. It's a really good alternative for patients to commencing legal proceedings, which are invariably stressful and can be very expensive, even with a no-win, no-fee setup. There's lots of literature to say that when people have suffered an adverse event in health, what they want is an explanation or an apology or an assurance that there are systems in place such that it won't happen again, or often all three. And these are the sorts of outcomes that can be readily achieved by the health complaints entities. I'll conclude with a quick overview of the options that our patients have in the rare event that things go wrong. A helpful way, I think, to think about it is in terms of the purpose. So the purpose of regulators, like the OBA, supported by AHPRA, is to protect public safety, and it can do so by imposing conditions on registration and, in the most serious matters, referring to a tribunal for deregistration. Whereas health complaints entities are about conciliating and helping the parties reach a confidential agreement. Civil law, in our context, a patient suing an optometrist in negligence because they've suffered a harm as a result of the patient's poor care, is about compensation, putting the patient back in the position they could be as far as money can had the negligence not occurred. And with regard to criminal law, the purpose is punishment and deterrence of criminal behaviour. When it comes to the difference between civil and criminal claims, the intention of the or the mindset of the wrongdoer is important. So at the least culpable end, we have negligent or unintentional errors, and they're usually dealt with by the civil law. Whereas reckless and intentional errors that are more serious are usually dealt with by the criminal law, and the degree of intention is important. So if you intend to kill someone and you do, that's murder. But if there's no intention yet a person dies as a result of your actions, that's often described as recklessness. So in healthcare, sometimes negligent, unintentional errors are so serious that they deserve the attention of the criminal law. And as Luke will explain, where there's a big departure of the standard of care, there is the prospect of being charged with negligent manslaughter, and that's where the UK optometrist Honey Rose was thought to be, that she was in the realm of making an error that was so serious that the criminal law should be applied. Thank you.
Thanks, Jane. That was very informative, and I really appreciate your time. I think you touched on something that is a real common misconception, certainly amongst practitioners and people that I've spoken to, in that APRA, the regulatory body, is actually looking after the interest of the practitioner, whereas in fact it's important for viewers and for optometrists to know that APRA's primary role is to protect the public, isn't it?
Indeed.
Yeah, and I think that's sort of really, really important that we touched on that. Before we let you go, Jane, you worked for a number of years as a medical defence lawyer. Can you share some insight into sort of your experience there? Any sort of real pearls that you learned in your time working in that space?
Sure. Two things spring to mind immediately. One is that good communicators tend not to get sued. Mm-hmm. And good practitioners, or the ones that are least likely to get sued, are aware of what I call expectation gaps. So when a proposed treatment or a test is not going to definitely lead to a positive outcome, that the practitioner will explain that in a way to the patient such that if something out of the ordinary happens, the patient is not taken by surprise.
Yeah.
Yep.
Yeah, excellent. Thanks, Jane. We really appreciate your time tonight. Ladies and gentlemen, to finish the night tonight, we've got our Chief Clinical Officer from Optometry Australia, Luke Arundel. Luke graduated with honours in optometry from QUT in 1998. He currently holds fellowship with the BCLA and the CCLSA and became an adjunct associate professor of the University of Missouri in St. Louis in USA in 2008. Luke's professional interests includes keratoconus, postgraft, scleral lenses, ortho-K and paediatric contact lens fitting. He's worked in specialist contact lens practices in Brisbane and Melbourne, has also worked in the contact lens manufacturing field for 4 years. He's guest lectured at state and international contact lens conferences. He's currently the Chief Clinical Officer at Optometry Australia, where he assists members with regulatory notifications and PII claims for the last 5 years. Luke, bring it home.
Thanks, Simon. It would be a lousy legal lecture without a legal disclaimer. I am an optometrist, and the information tonight is for general purposes only. We're going to be touching on these ones: avoiding manslaughter charges, and of course avoiding legal charges and regulatory investigations that Jane has already highlighted. To kick things off, if you had have asked this very fresh-faced person 20 years ago whether the practice of my profession would result in me ending up here, I would have told you that you're dreaming. It didn't even cross my mind. If you had pushed me, I imagine it probably would have been something more like this, but George Clooney is yet to return my calls. However, this came across my desk when I started working for OA. We have media monitoring, and this was obviously quite concerning. So in 2015, we have a Boots optician, the first to be charged with negligent manslaughter after the death of a boy following a routine checkup. Now, she claimed the examination was difficult because Vinny closed his eyes and looked away during a test. That's pretty much every paediatric consultation I have done. However, photos taken clearly revealed bilateral papilledema that required urgent treatment. Now, it's been touched on tonight. She, in her defence, claimed that she looked at the wrong photos. So whether they were previous photos, whether they were photos of a different patient, didn't come into it, but she has not looked at the correct photos. So obviously a very valid point from Steve to start things off. How did the case progress? Well, here she is, guilty. July 2016. It obviously takes a while for these things to cook. And it was described as the first of its kind in the UK. Now, it took 10 days for the jury to come to that decision, and the prosecution said that her failure to identify the condition through the photos and refer Vinny for treatment amounted to gross negligence, causing his death. From there, we find that the decision's been overturned, July 2017. The prosecution's had another stab at it here. October 2017, they've been shut down, and that's the end of the case. Whether or not she will ever work as an optometrist again is a different question. It is still pending on her registration details on the GOC. So, breaking down some of the legal mumbo-jumbo for you, essentially, how did she escape going to jail? Basically, if she had done the exam properly, she would have known that he was at risk of death. She hadn't done it properly, so there's no way that she could have known that he would die. And while she was negligent, she couldn't be found guilty of criminal negligent manslaughter because she couldn't reasonably foresee that he was going to die due to her actions. So let's flesh it out with a little bit of terminology. So negligence. Did the professional owe a duty of care? Did they breach that duty of care? And did harm actually occur? All of those things need to be satisfied for a claim to be successful. Moving on to manslaughter. So it's the legal term for homicide considered by law as less culpable than murder. It's got nothing to do with this case. I just find it interesting when I was researching it. The distinction has been around since the 7th century BC. And of course, the exact definition is going to differ from jurisdiction to jurisdiction. So criminally negligent manslaughter, putting all this together, as Jane alluded to, it occurs when a person causes the death of another through an act or omission that carries with it a high risk that death would follow. And the standard of care has got to be far below, what we could expect from a reasonable practitioner. So let me give you an example, something a little bit more real world. What would count? And this is obviously in our sphere. We have a doctor who has failed to notice an alarm that's been beeping away for 6 minutes. This is during eye surgery. A breathing tube has disconnected from the patient's mouth. The patient subsequently went on to die. So that's not rocket science. No breathing tube, it's pretty obvious that patient's going to die. No further testing would be required to be able to foresee that outcome. And if you're looking for something from the real world, perhaps, leaving a child locked in a car on a hot day could potentially result in a fatal outcome as well. So digging into some of the background, and the reason we're talking about this, there was obviously a lot of concern at the time because the UK and Australian legal systems are similar. So we've got our lawyers to have a look at it to see whether or not we really need to be stressing about this here in Australia, and we'll come to their verdict at the end. So the first principle, there must be a serious and obvious risk of death at the time of the breach. The potentially life-threatening seriousness of Vinnie's condition wouldn't have been apparent unless and until she'd carried out a proper exam, and she failed to do so. So for this reason, they had suggested, or the court said, it's not appropriate to take into account what the defendant would have known but for their breach of duty, and hence she managed to escape. So we talked about negligence before. The addition for manslaughter by gross negligence is that the circumstances of the breach were so truly exceptionally bad and so reprehensible as to justify the conclusion that it requires criminal sanction. So essentially what they're saying is, don't be really, 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 really bad. Now, English law, the possibility that an assessment might reveal something life-threatening is not the same as an obvious risk of death. So think back to that breathing tube being disconnected during surgery. That one's pretty clear-cut. And at the end of the day, the court said that it certainly did not condone the negligence that led to his death. And of course, that thinking about that poor child is going to stay with that lady for the rest of her life. They said that, however, it does not constitute the crime of gross negligent manslaughter. So that's where we've ended up. Closer to home, our lawyers dug some cases up for us. For me as an ex-Queenslander, Dr. Death certainly received a lot of media attention back at the time. That was overturned by the High Court. And that's not necessarily because he wasn't in the wrong. It is quite possibly due to the fact that the prosecution changed their strategy halfway through, and it was thrown out by the High Court. So we can see some other cases here. Interestingly enough, a manslaughter conviction against a naturopath. And our lawyers had suggested that there is a greater propensity for English doctors to be charged they highlighted that there are significant legal difficulties in obtaining such a conviction here in Australia. We have a fabulous country, but made up of various different states with complicated and different legal systems. These ones they flagged as most likely to end up as an APRA complaint or as a civil suit. Implications. Now, it is very important. And for me, watching this case transpire, it was incredibly interesting to see the rallying from the medical and medico-legal profession. There were fighting funds. There was a lot of discussion about it because, being found guilty of gross negligent manslaughter by reason of negligent omission to carry out routine eye and blood tests, is going to clog up health care systems. So, if I send every child who's a bit squirmy and who closes their eyes during an eye test down to the eye and ear hospital, it is going to delay appropriate care for those children that really need to be seen urgently. So it was criticised heavily in England in that it would encourage defensive medicine, which would not necessarily lead to better health outcomes. Here in Australia, the health law academics said that it would create a culture of fear and cover-up within healthcare. So should we panic? The summary was essentially, we are not immune to prosecution for manslaughter. The level required for conviction is very high. And to put things in perspective, since the first case of medical manslaughter 165 years ago, just 4 doctors have been convicted. 2 of those cases date back more than 100 years. So their verdict was no. Look, we probably shouldn't be panicking about going to jail anytime soon. Bringing things a little bit closer to home. So I'm going to be talking about some of the more medico-legal claims that we see popping up at OA. Jane's highlighted obviously some of the disciplinary matters, but it's really diagnostics. So this is similar across the professions. 40% of optometry claims are diagnostic. They account for 98% of damages awarded. Things around glasses, 2%, it's a drop in the ocean. Those ones really shouldn't be getting to medico-legal. Probably more expensive to employ the lawyer than it is to pay those ones out. Claims overview, in red. The reason that we have Steve helping us tonight is they are expensive claims. He's talked about it. That's why we want to make sure that we aren't missing those ones. We can have failure or delay to refer from a variety of things, and I'm not going to touch on these ones because they're not super common. Now, one thing that I really want to impress, your PII, your professional indemnity insurance, and your assistance from OA is not exclusive to getting sued. We can also assist you. We also have lawyers that will assist you with disciplinary and registration board complaints. So call it in, get some help. And the priority is getting help ASAP. The sooner we get onto these things, time is important. It's when a patient stews on things that they can lead them to going down the legal pathway. What comes into the lawyers? They put this slide together for us. Obviously, there's a variety of things, but yeah, possible complaints heading off the list and actual complaints being received right after that. Now, I apologise if anyone's watching the webinar on a phone. I'll talk you through the bits and pieces on this slide. In the bars, we have payouts, and the line is frequency. So we see delay and failure to diagnose, high frequency, and results in a high payout. On the left-hand side of your screen, glaucoma is the first bar. The next one is tumours, other melanomas, and then the third bar is retinal. So that's where a bulk of the money that's being awarded in compensation or other claims is being paid out. And interestingly, the second one for tumours, low frequency but high payout, as we mentioned. Really interesting to see that therapeutics, again, barely a blip on the radar, so please don't be afraid of prescribing. As general interest, what's out there? What kind of claims are we seeing day to day? What's cooking at the moment? So this is a fairly extended period. Notifications in orange, disciplinary matters there in the yellow. We do have criminal matters, coronial inquests, and compensation claims are always fairly much ever present. I put this slide in, really for one reason only. These things can take a really long time to get a result. And, 55 months, for goodness sake, that's a long time to have something hanging over your head. AHPRA's aware of it, obviously the lawyers are aware of it, they have counselling services, in some cases, but these things can take a significant detrimental effect to your mental health and well-being. They are very stressful, having a claim hanging over your head, and it can take a long time to close them out. This is purely just a how are we doing state by state here in Victoria. Not so good over the last 12 months. And open matters, a lot of disciplinary stuff, compensation claims, and the age of those claims are in this slide. So it's been touched on. I'm going to lightly touch on it again. Communication, take the history, educate and inform the patient about their options, and perhaps most importantly, ensure that the patient knows what to do if the condition doesn't improve or deteriorates. Give them clear instructions. If you're a slow typer, get one of these guys. I really like the pre-filled drop-down boxes that Steve talked about. And I can't stress enough, no records, no defence. I've been a locum, I've seen cards that have a tick for internals, that's unhelpful. And you have no defence if anything comes at you in that type of situation. Steve talked about including negative findings, really important. If I've got someone that comes in with flashes and floaters, obviously that's a trigger to do a DFE, but I will write down no retinal detachment observed. Okay, it's really clear that I've looked for it and I haven't found it. Negative Schaefer's sign. These things obviously are very helpful. Checking the patient records. I'm a contact lens guy. It doesn't really matter if I do an amazing bilateral mini-scleral fit on a graft patient if I let their retina rot away. So, it's problematic for me because I tend to see them so often in a short period of time. It's easy to forget that, I need to be checking that pink bit at the back of the eye every once in a while as well. So, make sure you're not dropping the ball on those kind of things. Have a proper recall system in place. Again, Steve's talked about it. For me, it's a spreadsheet. Outgoing referrals are logged at the end of every month or as reports come back. The admin staff tick it off on that spreadsheet. Anyone we haven't received a report for, they call, they follow up. Anything problematic obviously is escalated up to the optometrist. And, I personally think it's unfair, but the duty is on us, okay, to make sure that they attend or that they make a conscious decision not to do so. So, it's a question that we do get asked at OA is, can I make them attend a referral or go and seek help? Look, we can't make them go, but you need to make sure that the possible negative ramifications of failure to attend for further consultation or treatment has been explained to the patient and that it's been documented. So, whether it's a registered letter for failure to attend, a referral, failure to come back for fields if I've noted that their discs are raised. These things, add to layers of protection for you. Shared care, again, problematic. Is my corneal specialist doing the retina? Am I doing the retina? How are you going to find out? You've obviously got to have two-way communication. Make it clear who's doing what. There's been quite a few things that have made me do the OMG face, taking calls at OA. I'm not the world's best retina person, but there are some things that really makes me wonder. Cataract, how are we getting sued for this? We know this. Delay or failure to refer for cataract comes up and we lose. Let's have a look at a quick example. Potential situation. Patient comes in with this. These are the record cards for these two patients seen by two different optometrists. 18 months down the track, patient gets a red eye, goes to the GP. GP refers to their off-thou friend. Off-thou friend says, great, I'll fix up your red eye, that's no problem. Hey, by the way, you've got cataract. I'll take that out for you. Next thing you know, you've got a letter alleging failure or delay to refer for cataract. Who would you rather defend? It's a trick question. Optom B never gets there. They made a record of those lens changes. They discussed it with the patient, and they told them what to do if something didn't get better. So they might have had a really sharp decline, from 12 months to 18 months. If things were getting worse, it's important to let them know, come back earlier. I love this one. There's a reason why it's taped to every slit lamp in clinics in the Northern Territory. It's really good for for recording lens changes. Don't just put mild lens changes. Try and quantify it. Summing up, first of all, borrowing from Hitchhiker's Guide, don't panic. You're unlikely to be going to jail anytime soon for the practice of optometry. Stuff happens. I find triaging calls at OA quite often. I will think, what would I have done in that situation? There's many situations where I would have done exactly the same thing. Often it's the roll of the dice. But what I can't stress enough is, don't make it easy for them. And Steve's really highlighted that with talking about the record keeping. No records, no defence. Simply can't stress that enough. My obligatory OA plug, we have excellent cover for you. It exceeds the guidelines imposed by the regulator, vastly exceeds them. There is nil excess. It's not like car insurance. Don't worry about your no claims bonus. There is no such thing. Call it in, get help. We have a hotline there. Criminal charges are covered. That's rare for bargain basement policies in Australia. Practice entity, charity work overseas, these things, practice staff working under your instruction. Unlimited retroactivity on claims, that's important. It might take 5, 10 years for one of these tumour things to come to fruition and for them to be in a position where they're actually wanting to take you to the cleaners. Defamation, privacy, coronial inquest, these kind of things are obviously covered, and I can't stress enough, APRA and regulatory investigations are covered. Get some help. We can assist you with your response. I've alluded to the fact that it's very stressful. Don't go it alone. We have an expanded member service and optometry advancement team at OA. Call it in, talk to one of our friendly optometrists. We will guide you through the process. And in as far as your to-do list, we can't cover everything tonight. We've had a pretty good stab at it. We have a vast amount of resources on the website. Go to the website, it's in professional practice, and it's under the Avant tile. Podcasts, our articles with real cases, and advice on how best to protect yourself day to day. And if in doubt, call it in. That's what we're there for. We're there to help you at the end of the day.
Like a perfectly timed runner, Luke. You did absolutely everything we asked of you in just the right time. Look, we've got 5 minutes. We're going to take a couple of questions for the panel. Luke, while we've got you in the hot seat, we might as well throw one at you. Someone's asking, when is the best time to notify OA or the insurer? Is it when I get a letter? Is it when I respond to that letter and it escalates? When is OA ready to step in?
Yeah. Look, it's a really good question. I might just tackle it in two different ways. I can't stress that it's important to, be conservative. Call it in, if in doubt, okay, is the short answer. The reason that I would say that, working with insurers, you don't want them to be, to give them any opportunity to weasel out of a claim, okay? Something, that comes straight from our policy. And there's similar wording in each and every policy that we've examined because we're obviously continually checking to make sure we're giving you the best cover. If you do not notify us of an incident or claim as soon as practicable, you may not be covered under this policy and your right to indemnity may be significantly reduced by us. Now, there's a good reason that they say that. The sooner you get onto these things, the better. We talked about, that first 72 hours are absolutely critical. But getting things ready, getting a defence team, and if necessary, taking those steps. Jane mentioned, sometimes they want an apology. Sometimes they want an acknowledgement that you are going to change your systems to make sure that when you drop the ball, it's never going to happen again. These are the kind of things that they're looking for. And that may be enough to head something off.
Sure.
Tackling it more precisely, perhaps, if we were going to get nitty-gritty, and again, it will be different from different policies, but for us at OA, it is when a patient has suffered a major complication. there is an error made causing harm. An adverse outcome results in significant anger in your patient or their family. You receive a letter from a solicitor indicating dissatisfaction or requesting a patient record. Obviously, that's a heads up. Okay, let us know. Let's start building a defence for you that something might be coming. And the last one, it's very vague, but it alludes to the fact that err on the conservative side. If you are concerned that an incident has occurred, okay, it can't really be broader than that, which you may think, which you think may lead to a claim.
Sure.
So, that's pretty much it.
Okay, and it's fair to say, you did mention the example of the cataract patient who gets sent by the GP to the ophthalmologist. You never made a record that they were grade 3 cataracts, and so you get a letter saying delayed to refer, those sort of things. Someone says, well, what about the patient who ends up going to the ophthalmologist for another reason? The cataracts are taken out, but my records suggest that they weren't ready and the ophthalmologist was keen to do the surgery. So the end result is usually what?
Yeah, it again, it's going to be case by case, of course. And we know things can go downhill very suddenly. And at the end of the day, that's maybe why I'm trying to allude to the fact, try and make your recordings objective if possible. Mild lens changes, that could mean many things to many different people. Sure. If you've graded it objectively, that helps. And, and it is a worry. If you've got a surgeon with a quiet surgical list who's, nudge things along a little bit, that could potentially be problematic. But, as Steve said, your records are your defence. So, if you've recorded where it was at that point in time, that's, what you're going to be basing your defence on, and fingers crossed you'll win.
Steve, someone's asking, if you have a patient with headaches and you say to them, go and see your GP, and you write a letter to the GP, in fact, saying, Mr. X, I'm sending them to you for headaches, is that enough?
No, it's not. If I was sending a patient to a GP for headaches, it's because I've gone through a process of eliminating ocular possibilities, visual possibilities.
Sure.
And I've also eliminated, to a reasonable degree, by tests and questions, neurological company. So I don't believe it's urgent, but I want them to be tested by a GP for blood tests and other things. Also, I'm not going to send them to a GP to order an MRI because GPs don't do that, and the patient doesn't get a rebate. Well, they do it, but patients don't get rebates so easily. So if I think it's urgent and it needs imaging, they're going to be sent off urgently. If I think if I've checked everything out, from my point of view, there's nothing sinister, urgent, then I'm going to send them to the GP because I believe there's a potential health issue that might be causing this problem. So I'll write that in my letter, what my recommendation is, and record it very carefully.
Okay, thanks, Steve. And Jane, perhaps one just to finish up with your your OBA hat on and sort of your experience at that level. One of our members is asking, optometrists and their ability to request imaging and the future of optometry around being able to order imaging and that expansion of scope. What's your take on that, or what's your experience in that space?
That's really about funding by our federal government, and so it's not really a matter that the Optometry Board of Australia will get into. That's more a matter for the association.
Right. Okay. I would at this point like to thank Steve, Jane and Luke for your time and your expertise this evening. Ladies and gentlemen, thank you for joining us this evening. As I said at the beginning, your points will be allocated to you at the conclusion of the webcast in the coming days. We hope you enjoyed it and we look forward to seeing you next time. Have a great evening. Thank you.